Professor Cohen, thank you so much for joining me. I have to ask, and this might be like a bit of a hot button question, but what is the post-Dobbs reality right now?
So it's interesting because in some ways it's exactly what we expected. In other ways, it's not at all. Um, it's expected that a bunch of states would ban abortion. We kind of thought it might be close to half the states. It's been lower than that. Right now, there are 12 states with complete abortion bans. Another 7 or 8 states have bans on abortion that are before what Roe v. Wade would have allowed. And so for people in those states, they're faced with some difficulties in terms of getting care. But in that regard, that's where we've seen the big surprise. Abortion numbers have actually gone up after Dobbs. I think most people thought they would go down, some down quite significantly, right? If a third to a half of the country bans abortion, then numbers would drop. But they've actually gone up, and there's a whole host of reasons for that. But that has been a big surprise. Now, that doesn't mean everyone who wants or needs an abortion is getting one. But it means a lot of people are, even though they are still living in states where abortions are banned. And, they're doing it through travel or pills or other means. But that's probably the big surprise post-Dobbs. So I think it's been a really complex situation in a lot of different ways.
When you talk about the different methods now that people can go about getting an abortion, it's making me think of the Dr. Carpenter case with New York and Louisiana and New York and Texas. And there seems to be like a practice area connection here from like health law to criminal defense to con law. And there's like quite a few ways to like jump into this abortion law subject. Can you talk to us about the full faith and credit clause and how abortion shield laws like kind of like directly test that?
The full faith and credit clause requires states to give effect to final judgments from other states. If you and I are in a car accident in New Jersey, and I live in Pennsylvania and the verdict is in New Jersey, you might try to get the verdict from me by going into Pennsylvania and saying, hey, I got this verdict in New Jersey, but I need to now enforce it against someone who lives in Pennsylvania, which is where I live. So Pennsylvania courts, please respect the judgment and enforce the judgment from New Jersey. And that's required under the Constitution through the full faith and credit clause. But there are exceptions, just like most things that you learn in law school. There are exceptions to this rule. And a couple of those exceptions apply or might apply in the context of the case in Texas, where Texas has sued a New York abortion provider. At this point in time, early in February, Texas obtained a default judgment against her, basically meaning that she did not show up. So they got a verdict for over $100,000. But now they have to enforce it because she's in New York. Now, if this were a normal case, just like I described the car accident, the hypothetical car accident, Texas would go to New York and say, hey, enforce this judgment, and it would. But there are two exceptions that come up here. One, if there's no personal jurisdiction over the defendant, think back to 1L Civ Pro, right? If there is no personal jurisdiction over the defendant, then they don't have to be, that verdict doesn't have to be enforced in the other state. And with telehealth, right? Dr. Carpenter provided pills allegedly to this patient via telehealth. There's probably personal jurisdiction, but that might be claimed that there's no personal jurisdiction over her because she wasn't in Texas. But I think more clearly, the issue is that the other exception is that when a civil judgment is really penal in nature, meaning it's punishment instead of compensation, then states don't have to enforce that judgment from out of state. So what does that mean? It means if I'm injured and the verdict is to compensate me for the injuries, that has to be enforced in another state. But if there's no injury, or if the verdict is not about compensating for injury, but rather for punishing someone for violating the law, that doesn't have to be enforced. And that's what I think has pretty clearly happened in the Texas case, because the plaintiff is the state of Texas, right? The state of Texas didn't suffer any financial injury or health injury or mental health injury. So the $100,000 verdict is really just punishment for violating what Texas thinks is its law. It's not being compensated for anything. And so New York's not going to have to enforce this law. And this is very well established under constitutional law. So I don't think it's going to be, it'll be controversial because it's abortion, but it's not going to be controversial legally that this is punishment. This is not civil compensation. And so New York doesn't have to enforce this out-of-state judgment.
I think you said one thing that made me think of another thing that's going to make law students groan. There's exceptions, which also leads to it depends, which is like our favorite phrase, right? Are shield laws like state sovereignty tools, or are they violating how some states are choosing to govern themselves?
So it depends which state you ask. So back to your favorite term, right? If you graduate law school without knowing how to say it depends, then you've done it wrong, right? So New York thinks that what it is doing is protecting its abortion providers who are following New York law, and that they are in the process expanding care for patients who can get care from New York licensed providers. Texas thinks that the shield law is infringing on Texas's sovereignty to control what happens within its borders because, for instance, the patient that allegedly Dr. Carpenter cared for via telehealth was in Texas borders. And so there's no doubt that there's two different views of these laws based on which state you're in. And I think that they would both claim they are doing something to protect and further the interests of their own state.
I think sooner rather than later, this is going to bubble up to the Supreme Court, whether it be something to do with state interplay directly or an actual piece that addresses abortion in this way. They're going to have some pretty big questions to tackle, including maybe fetal personhood or, the full-on resuscitation of the Comstock Act. Where can this really go federally, do you think?
So I don't know if the Supreme Court will get into this soon. I think there's lots of reasons why the Supreme Court takes cases. There's also lots of reasons why the Supreme Court doesn't take cases. I'm not in the camp that they are definitely going to take this case. Predicting the future like that is really hard, especially when there are lots of interests involved. They may take a case related to this. It may be this year. It may be 10 years from now. I have no idea. I can't predict the future. But I don't think it's a foregone conclusion. That being said, this will certainly work its way through the lower courts, whether it's New York State Court, Texas State Courts, federal courts that cover one or the other. I'm sure, what's happened so far with the default judgment in Texas is not the end of the matter in this case. So I would get, all but guarantee that there will be future court decisions here. But like I said, I think New York, to the extent that it denies the enforcement of this default judgment in New York State, is on incredibly solid ground. So I would be surprised if any of the New York courts say otherwise. And same with the federal courts, just because this this penal exception to the full faith and credit clause has been established for over a century. It's firmly within Supreme Court jurisprudence. And it's really up to the Supreme Court to change that if it wants to, which we know it can, but the lower courts can't. They have to follow this.